Hello aspirants. Today we are going to discuss a very important topic. This is about 42nd Amendment which took place in our Indian Constitution, and this is famously called as the mini constitution. Interestingly, multiple changes were placed in the Indian constitution because of which it has been given the name the mini constitution. In this video, we will see that why such name has been given and what are the key changes made in the Indian constitution and what was the main reason behind bringing this amendment. So stay tuned. So the history goes that back in 1975, as we all know that there was a national emergency declared by Indira Gandhi. Now ये emergency declare क्यों की गई थी? Because there was an internal disturbance in the country because of which Indira Gandhi declared this emergency. Now, many people criticize this emergency because this emergency lasted for 21 months और ये emergency start हुई थी 1975 में और ये चलती है 1977 तक. अब सबसे बड़ी प्रॉब्लम ये थी इस emergency में कि इसमें सारे fundamental rights को कर्ब कर दिया गया था. कई सारी पॉलिटिकल पार्टीज जो ओपोनेंट में थी उन्हें हाउस अरेस्ट किया गया और स्टेट्स की सारी पावर सेंट्रल पे विड्रॉ कर ली जाती है. So because of all of this issues, the central government had the enormous power at their end and they somehow misused it. So considering this, Parliament wanted to bring such amendment which will favor the central government from all the sides and it will help the government to rule further. So because of which in 1976 this 42nd amendment was brought in our Indian constitution. So we will see that what are the multiple changes which have been done in the Indian constitution. So one of the prominent change, major change. So first I will give you the highlight. So this highlight is the first change was made in the preamble. Then the changes were made in 40 articles and also in the 7th schedule. Thereafter 14 new articles were added and new 2 parts were added in our constitution. So I have written here COI. COI means Constitution of India. So the first change was done in the preamble. So I have pasted original preamble which you can see in the screen. So this preamble is missing with the 2 words which have been added with this 42nd amendment. The words are socialist and secular. So earlier we just had sovereign, democratic and republic. These were the only 3 words which were there in the preamble and later on it turned out to be sovereign, secular, socialist, democratic and republic. This word plays a lot of value, a lot of role in our daily functioning. Thereafter, the minor change was also done where unity and integrity of the nation was added, whereas earlier it was just the unity. Thereafter, multiple changes took place in Directive Principles of State Policy. Now, Directive Principles of State Policy क्या होती है? This is a very simple thing. So basically, कभी भी जब state कोई policy बनाती है which turns out to be a law later on, तो उस policy को बनाने के लिए कुछ directive principles हैं जो हमारे constitution में दिए गए हैं. And it is advised, it is recommended that whenever state is making policy, state को इन directive principles का ध्यान हमेशा देना चाहिए. Although as per our law, these directive principles are non-enforceable in the court of law. Yet the government is advised to adopt these principles while making the law. So there are certain changes which has been done in the directive principles as well. So the first changes is, first of all, 3 new DPSPs have been added and minor changes done in Article 39 subclause F. Now, Article 39 subclause F had a healthy change because the change was that children has to be given more opportunities and they have to be given such facility in which they can develop in a healthy manner and they shall have a condition of freedom and dignity with which their childhood and youth can be made better and protected against exploitation. That is how later 21A got added, with which right to education was ensured, and already we had 23 and 24 which protects our children from exploitation. Thereafter, 3 new DPSP has been added. The first one is Article 39A. This promotes equal justice and provide free legal aid to the poor. Later on, this has been transferred to the Article 21 of the Constitution, making it to be the right of an individual, which was done by the case of Husnaira Khatun versus State of Bihar, which was a good change. Second is Article 43A. This seeks that there shall be a participation of the workers in the management, which is another good change with which we can make sure that workers are also involved in the management so that they can decide their own good beliefs. Then 48A was another good change with which we have protected and improved our environment. So this was the directive which has been added, that the environment shall be protected and be improved and safeguard the forest and wildlife. So why this has been added? Because multiple time under the garb of the infrastructural development, many trees have been cut down, many forests had been cut down. So now multiple laws have been made to improvise this constitutional principle with which we can protect our wildlife. Then fundamental duties. Fundamental duties have been added in Part 4A. So Part 4 was Directive Principle of State Policy. Now they have carved out new part, which is Part 4A, and 10 fundamental duties have been added. This fundamental duties have been added based upon the recommendation of the Swan Singh Committee, which was established in 1976 itself. So thereafter, one more duty was added post the introduction of Article 21A, which says that parents had a duty to make sure that their children are well educated. So there are 11 duties in general. Now, Judiciary. These were the major changes which were brought in by the 42nd Amendment. Now, what was the problem? The problem was Judiciary had a certain responsibility, specifically to review the laws made by the Parliament. अब आपने इस अमेंडमेंट से जुडिशरी की मेन पावर ही छीन ली. So जो मेन पावर थी लॉज को रिव्यू करना, और पार्लियामेंट ने बोला कि अब स्पेसिफिकली हाई कोर्ट कुछ स्पेसिफिक एरियाज पे रिव्यू नहीं कर सकती. So this was the major changes made for the judiciary, and they also provided for creation of All India Judicial Services, which till date did not formalize. Thereafter, the major change was made for Article 323A and 323B. So this was a good change with which we have introduced administrative tribunals. So administrative tribunals have been introduced to reduce the workload of the courts so that the specialized tribunal can take up the matters and do the speedy justice. Thereafter, few more changes made in the working structure of the parliament. First thing, that already we know that our president has powers which are nominal in nature, but real power lies with the prime minister. With this, they made sure that the president is bound by the advice of the cabinet. And why did this so happen? Because back in 1975 again, Indira Gandhi clearly told to the then president Fakhruddin Ali to declare the emergency under Article 352, and that's how Fakhruddin Ali was bound to accept the advice of the cabinet, and they agreed. Thereafter, they allowed center to deploy forces on the state level to control the situation in which there is disturbance towards law and order. This is Article 257A. Thereafter, they give the special discretionary power to the Speaker of Lok Sabha and Prime Minister under Article 329A. Thereafter, they given the precedence to directive principles over fundamental right, which was considered to be the biggest legal blunder, that in no case directive principle which cannot be enforceable in the court of law being given precedence over fundamental right, which have been considered as a heart of the constitution even by our great legal scholar Dr. B.R. Ambedkar. So in this case, it was a mockery of our legal specialist, and soon later on, this specific part was overruled by the Minerva Mills case, where the Supreme Court struck down this part that in no manner directive principle can be given superintendence over the fundamental right. So these were the few important changes, and thereafter one major stroke made by 42nd Amendment was the suspension of fundamental right. अब हमें ये पता है कि fundamental right एक हमारा बहुत important segment है, and with the डेवलपमेंट्स ऑफ मल्टीपल केस लॉज, कोर्ट ने भी ये कंफर्म किया है कि फंडामेंटल राइट कैन नॉट बी कर्ब्ड एट एनी पॉइंट ऑफ टाइम, स्पेसिफिकली आर्टिकल 19 and article 21. So with this, the 42nd Amendment made sure that the power lies with the Parliament or the central government more, and the rest of the organs may be weakened. So that is why they introduced this part, and they said that there will be no prior or special notice and all of your fundamental right will be curbed, specifically Article 19. Now, why Article 19? Because Article 19 gives us a very important fundamental right, which is a freedom of speech and expression. So now as soon as this is curbed, you cannot raise your voice against government. आप government के खिलाफ कुछ भी नहीं बोल सकते. Now we have a provisions called sedition, which is utilized to counter this freedom of speech and expression. However, later on, this also got suspended. So this was all about the 42nd Amendment. We saw there are multiple twists and turns in this amendment, and there was a very impactful history because of this specific amendment, and multiple case laws were developed which helped to shape our Indian Constitution better. So if you like the video, please share and subscribe our channel, and see you in the next one. Thank you.